Hello everyone and welcome to today's lecture. Today we will be talking about understanding whiteness as property and specifically looking at how whiteness as property persists. So throughout this particular series of lectures dealing with Cheryl Harris's whiteness as property, we have covered quite a bit. So what does our roadmap look like for today? Of course, we're going to start with a flashback as we traditionally do. Then we're going to look at why whiteness as property in its perpetuation is important. And we're also going to look at how whiteness as property is perpetuated. So let's go ahead and get started. Firstly, we started off this series putting Cheryl Harris's particular article in context by defining out what property is, and not necessarily in terms of something that you own or real estate or a car. We literally looked at the philosophical development of property, the idea that you can own something within the development of the Western world. And specifically, we looked at the founding ideas around property. Then we looked at the traditional rendering and understanding of property, and we moved to the modern understanding of property. Then from there, we looked at how whiteness itself became enshrined in law and how this took place. And we looked at a number of instances to understand how this happened. We looked at the colonization of native and indigenous peoples as well as land. We looked at slavery. We looked at the Constitution. We then looked at the Naturalization Act of 1790. We also looked at the Black Codes, which were instituted after the Civil War. We looked at the Chinese Exclusion Act. We looked at Jim Crow as well as Japanese internment. And what these particular case studies that we were able to look at clearly mapped out for us is that how whiteness became propertized in law and that it had a property interest that was protected by law. And moreover and beyond that, we were able to define out that property is both tangible and intangible, that it both accrues and retains value as well as extends rights. After we walked through that lecture, we then went to Plessy versus Ferguson and Brown versus Board. This was lecture 2 in the series. And specifically, we looked at what took place with Homer Plessy in Louisiana when his case went before the Supreme Court, because it is this case that really helps to give context to where we are now in the 21st century. And that Plessy versus Ferguson is a case that gives us separate and equal. Of course, we know that separate is inherently unequal because of the ways in which the rights, the privileges, the entitlements, etc. of whiteness as a form of property require their particular facilities to be built better and, of course, outfitted with better amenities and different things of that sort. Nonetheless, Plessy versus Ferguson gives us separate but equal in law. That is that it was required by de jure, by actual law, that the property interest in whiteness be both acknowledged and preserved. And when we go back and read that opinion, that if there is a violation of that takes place, that it becomes actionable. Right? This is all in the second lecture or part 2 of this series. So if you missed that lecture, that will be week 2, lecture 2. Make sure you go back and watch that. And then we moved over to Brown versus Board of Education, and we looked at both parts 1 and 2. Remember, in part 1 of Brown versus Board of Education, also known as Brown 1, that is when a decision is made that schools must desegregate, versus Brown 2 is when they set up the framing for how that desegregation is to take place. And what the Brown case does is it moves law from acknowledging the property interest in whiteness from a de jure aspect to a de facto aspect. That is that it comes by custom. It becomes a social norm. And key in the Brown versus Board of Education case, you will remember, is that they said that schools had to desegregate. However, and we're talking about Brown 1 here, however, the court did nothing with the material differences that had taken place over both space and time. They did not say, okay, well, money has to be reallocated over here. These resources need to be put in these schools over here. They just said you have to desegregate. And what that allowed for was inequality to become the new standard in society. Therefore, inequality was seen as equality so long as students of color, those who were non-white, had access to white schools, presumably, because in Brown 2, remember in the framework that they laid out, not only did they pass how desegregation was to take place back to the states and local school boards, they said that you must do so with all deliberate speed as opposed to immediately, which allowed local school boards and states to take their time. And in this way, inequality becomes not only perpetuated, right, but it also becomes the social norm. So if you missed lectures 1 and 2 of week 2, make sure you go back and check those out so that way you are fully up to date. With that being stated, let's go ahead and lean into why whiteness as property and its perpetuation is important and what it is that Cheryl Harris is getting at here. And she has 2 reasons why she says that looking at the perpetuation of whiteness as property is important. Number 1, she says that it causes the othering of groups and individuals to continue via assigning different racial identities and causing those particular differences to matter not only in law, but also in institutions within society. And then secondly, she says that whiteness as property remains. So let's take each one of these 2 reasonings here in turn. So in looking at problems that are associated with assigning differences via racial identities and how that has not disappeared, Cheryl Harris says this, right? That to the extent that the practice of othering continues via the distinguishing of racialized groups as a means of harm, then political and social misrecognition is perpetuated and becomes a social norm. Now, why is this important? To underscore why this is important, I want to take a look at what Melissa Harris Perry says in her book, Sister Citizen, which I certainly recommend as a read. This book is outstanding. Make sure you get this if you have not read this book as of yet. Melissa Harris Perry says this on page 8 in on page 38 in her book, Sister Citizen. She says, an individual who is seen primarily as a part of a despised group loses the opportunity to experience the public recognition for which the human self strives. Further, if the group itself is misunderstood, then to the extent that one is seen as part of this group, that scene, that social scene, that political scene is inaccurate. Inaccurate recognition is painful not only to the psyche, but also to the political self, the citizen self. She goes on to say, misrecognition in public has a profound impact on the private self. And there's a few things to pull out here. That as this insistence continues that the property interest in whiteness be recognized, what that also means is that the harms, the misrecognition, right, the inaccurate way of seeing the world, or as Charles Mills says, the inverted epistemology, that inaccurate recognition becomes painful to the psyche of the individuals that are on the opposite receiving end of that. In other words, that the continuation of recognizing the property interest in whiteness and retaining its value and extending its rights has an impact on those who are negatively impacted by it, by way of psychological processes and how they understand themselves in society. That this goes further than law. That this goes further than what one can do in society. That it literally impacts how one sees themselves and how one understands themselves and how one understands what is possible for themselves in society. Also, on the other hand of that, as Toni Morrison says and reminds us, that racism has just as much of an impact on white folk as it does non-white folks. Why? Because she says that if you can only be tall because someone is on their knees, then there is a serious problem. And that this has inflated a whole class of persons to believe themselves to be something that which they are not. A powerful piece that I am going to suggest that you all read is a piece by James Baldwin called On Whiteness and Other Lies. You can literally type it into a search engine. The PDF will pull up. He wrote it in Essence magazine. And the thrust of his argument is that you have a whole classified group of persons that believe that certain things are possible for themselves, and they believe their social positioning is something real, all because of a fictive identity, right? That's one side of it. Then on the other side of it, you have a whole class of persons that have been racialized and others that believe that the delimitations that have been superimposed in their lives is actually something real. And how do both sides of the equation become real, become made manifest in society? It is because of the Western ideals that have been erected and that have been superimposed in society. In other words, that the property interest in whiteness is not just about recognizing the value and extending the rights, that it has an impact on how we see, understand, interact, and interpret one another in everyday society. This is why understanding whiteness as property in its perpetuation is important. Moving on to the second reason, Cheryl Harris says that whiteness as property remains because it has not disappeared from law. What's an example of that? Many of you will recall the black women who started a venture capitalist fund. And they started that venture capitalist fund because black women-owned businesses did not have access to funding to get their businesses funded if they had an idea that they wanted to get off the ground. Black women businesses have been historically excluded from those spaces. However, a group sued saying that we should have access to those funds and we are being discriminated against. And what is the implicit argument in that? That the injury of black women must continue via law in order to recognize the property interest in whiteness by way of extending its rights and recognizing its value. Do you all see the move that is happening there? So in order for rights to be asserted and the property interest in whiteness to be recognized, that means that black women in this instance had to carry the weight of what Danielle Allen calls in her text, Talking to Strangers, that's the name of it, Danielle Allen's text, the weight of democratic sacrifice. And what Danielle Allen means by that is that black women had to give up access to a venture capital fund that they established in order for a demographic group that has always had access to venture capitalist funds to be able to access the funds that black women had set aside for themselves as well. And that this particular process was facilitated via the courts. that the property interest in whiteness was recognized. And this is what Cheryl Harris means by that the recognition of whiteness as property has not disappeared, that it continues still in the present, in modern day, in contemporary society. So then, let's take a closer look at how whiteness as property is perpetuated. And it is perpetuated in three ways. It is perpetuated in that whiteness continues to be valued as a social identity. It is perpetuated in the denial of group identity. And lastly, as Cheryl Harris argues, that it is perpetuated via the subjugation of non-white others through affirmative action doctrine. Let's take each one of these in turn. Firstly, by dealing with the fact that whiteness continues to be valued as a social identity that Cheryl Harris is looking at. What we understand by way of reading the text, right? And by way of sociological understanding, this is an introduction to sociology, but if it were, we would go here. But nonetheless, what we understand is that most white persons do not fit the qualifications of whiteness. Remember that whiteness is both gendered, class, and in some instances predicated upon one's social location or positioning in society. Remember, go back to this moment of Charles Mills. Who is in the room when the Declaration of Independence is being signed, right? This is what I mean by you have to keep the lectures with you when I say this, right? You just can't, watch one lecture and then be like, okay, I forget about it. No, you want to keep these lectures with you, keep these ideas with you. Remember who is in the room. That there is also gender in the room, class in the room, that one's social positioning in society is also in the room. Therefore, when whiteness is constructed as a Western technology, whiteness in and of itself has qualifications. Yet, interestingly, those who don't qualify still understand themselves to be better off, catch it, to be better off than being non-white because of their proximity to those who are the social elite. Remember what Homer Plessy's attorney argued in his case, right? Go back to week 2, lecture 2, if you don't know what I'm talking about there, right? Accordingly, possessing whiteness as property becomes, as Cheryl Harris states, a type of consolation prize. Because while retaining whiteness as property does not guarantee that all white persons will win, it does ensure they will not lose, because they will never be socially conscribed to non-white groups which are located at the periphery of society. Sit with that for a moment. That even if they do not have the material wealth, those persons retain both political and social capital. So much so that they can place an unqualified candidate in office who pretends to represent their interest, playing to what? Their expectations, which derive from what? Their possessing whiteness as property. But when that candidate gets in office, that candidate acts against them. And as this is done, they marshal the rights, those who voted for that candidate, then begin to marshal the rights of possessing whiteness as property by occupying the public sphere with cries of regretting their vote, all the while not recognizing the rights derived by way of possessing whiteness as property have permitted them to carry out a national political experiment in the first instance. Think about that. That's pretty powerful. Let's move on to point number 2, right? In terms of how whiteness as property is perpetuated within our contemporary context by way of understanding some things. Let's turn to page 1761 in our reading Whiteness as Property. And this is why you have to keep these lectures with you, because you're about to hear some very familiar things. Let's turn to page 1761. Cheryl Harris says this, quote, in part, the law's denial of the existence of racial groups is predicated not only on the rejection of the ongoing presence of the past, but it's also grounded on a basic tenet of liberalism, that constitutional protections inhere in individuals, not groups. This is going to be important. In individuals, not groups. Remember that. In individuals, not groups. Here we go. As informed by the Lockean notion of what? The social contract. There it is. That is why we started with understanding the social contract. And Lockean, who is she referring to here? John Locke. Right? So if you missed that part, make sure you go back to week 1 and specifically lectures 2 and 3 within week 1. So picking back up. Quote, as informed by the Lockean notion of the social contract, the autonomous free will of the individual is central. And because we already studied the social contract, this is why we're walking through this step by step, we understand who is counted as and maps onto society as an individual. Catch it, right? Continuing on. What does she say? She says, indeed, it is the individual who, in concert with other individuals, elects to center into political society and to form a state of limited powers. And how do those powers become limited? By way of strict scrutiny. That if you want to do away with those particular privileges, powers, rights, etc., that becomes enshrined in law via whiteness as property and recognizing its property interests, then you're going to need a narrowly tailored definition to do so. However, those same rights are protected via the strict scrutiny at the same time. I hope you all are beginning to see how the lectures from week 1 and week 2 map onto one another. And you want to retain what's happening here in week 2, because obviously that's going to have implications for week 3. With this in mind, now let's take a look at a case study, right? Because remember, critical race theory is grounded in law. So let's look at a case study of the denial of group identity by looking at the Mashpee tribe versus town of Mashpee. Let's look at this case really quickly. So the case at controversy here is that persons of the Mashpee tribe are suing the town of Mashpee to retain ownership of land which was taken from them by illegal means. This should be setting off all types of bells from lecture 1 of week 2, right? And the case is important because key in obtaining the land back is that the Mashpee peoples had to establish that they were a tribe when the land was sold out from under them. In other words, the colonial regime that they were now subjected to required that they prove themselves to the very same colonial force which forcefully dispossessed them. Why? Because you have to keep these things together. The rights of the individual now exceeded the rights of a group. Do you see how these are connecting now? And what is important here is that the definition of what a tribe was set up by the government. The government being representative of what? The now colonial force that now occupies that land. And let's take a look at the definition. Let's look on page 1764 in Whiteness as Property. What is the definition that they set in place? The definition was, quote, a body of native persons, and again, I'm adjusting the language for our contemporary time, a body of native persons of the same or similar race united in a community under one leadership or government in inhabiting a particular, though sometimes ill-defined territory. And there are some key things that takes place here that I want you all to keep in mind here, because the notion that they put into the legal definition was that it is, as the quote says, that it is a race united in a community under leadership or government. Because we're going to have to connect back to week 1 in just a little bit. Right? So, here we go. The existence of the definition itself. Let's start there. Before we even go into depth about considering what the definition is saying, the very existence of the definition itself permits an understanding of two things. One, that the government of the colonial power, the newly erected and constructed sovereign, set the definition in the first instance. In other words, who is the definition for, and what socio-political work is the definition doing? Because definitions are for the definer, not the defined. Point number 2, that the government of the colonial power, in this instance the U.S., used the definition to determine if those who were native to the land fit its definition. That the definition itself is what? Narrowly tailored. There it is. Right? You have to keep this stuff with you. Importantly, we must consider how the authority to define was given. And that authority is rendered from who? The consent of the governed. And who are the consent of the governed? Go back to Charles Mills. Here we go, week 1. Those who were signatories to the originating social contract, who in turn passed down the property born of that contract, in other words, whiteness, to their posterity, who now remain both the benefactors of the contract and the contemporary custodians of whiteness as a type of property which retains value and extends their rights. You all see how this is connecting here? And moreover, as Charles Mills said about when the Declaration of Independence was being established, etc., who had to be ignored in that room, right? Go back to this definition on page 1764. In the definition, notice it says, united in a community under one leadership or government. Spoiler alert, that in this case of the Mashpee tribe versus town of Mashpee, the government finds on behalf of the town of Mashpee, and the Mashpee peoples do not retain their land. In other words, that their community that's in this definition, the community was not recognized. That their leadership in their formation of government was not recognized. You ought to be able to see the links with week 1 here. And accordingly, as a result of property not being retained, those who are benefactors of the contract, receiving whiteness as property, as a type of what? Generational inheritance, defined, determined, and delimited the lives of the Mashpee people. Because in order to retain the property interest in whiteness and have its rights recognized, the determination of those who are non-whites must rest within the hands of those who retain whiteness as property. Now, how was this done? because the jury determined that the Mashpee people began to assimilate into non-native spaces after obtaining citizenship in 1869. This is 4 years, by the way, after the end of the Civil War, right? When those who were Africans who were forced to the Americas and enslaved were freed, right? This is not a history class, so I'm not going to get into that right now, right? But the important thing to understand here is that in this moment wherein those who were enslaved were freed, but also subjugated to the black codes. We talked about the black codes, right? And peonage debt and convict leasing and all those things. So the ways in which slavery took on another name, as a text by Douglas Blackman is titled, that also the continuation of the dispossession of native and indigenous peoples continues. So then gaining access to the colonial regime as they did through citizenship, right? In order to do that, their land was forcefully confiscated. Because what they were trying to do was gain access to life-sustaining resources. And by way of gaining access to those life-sustaining resources, the colonial power required that they be dispossessed of their land. That because of their group designation, they were not entitled to own land. Only those who law recognized. Isn't that something? That case, by the way, was in 1978. 1978. And the perpetuation is continually happening here. So, what did this result in? This resulted in, of course, their land being transferred to the beneficiaries. This is why, keep week one with you, this is why Charles Mills said that although all white persons aren't signatories to the contracts, they are beneficiaries of it. Why? Because this resulted in the land of the Mashpee people being transferred to the beneficiaries of the social contract, who themselves were guaranteed the acquisition of said land by claiming ownership made possible via whiteness as property. And what is most significant here, beyond the land transfer, is in the mandated land transfer, by the way, is that law acted in such a way to disappear the Mashpee people by law and invisibilize them through whiteness, rendering the Mashpee people as non-cognizable before law and in society. And all this through a definition that was set up by law. Do you all see what's happening here? Right? Lastly, let's take a look at subjugation through affirmative action doctrine. And specifically, we're going to look at the Regents of the University of California versus Bakke. And we are also, which is also coincidentally 1978. And then we're going to take a look at Students for Fair Admission versus Harvard, which is 2023. To let you know that this is not just something that remains in the 70s, the 80s, and the 90s. This is right here with us now. So let's do a quick run through of what is happening in University of California versus Bakke. Well, Regents of the University of California versus Bakke. So affirmative action Supreme Court cases of the 1980s and the 1990s, as well as contemporary collegiate admission cases, which is the Students for Fair Admissions versus Harvard and other cases as well, make clear that both the property interests and whiteness and the objective to protect it in law is still a very real thing. This is what I meant by in the orientation, that not only is critical race theory historical in its scope, that it also deals with the present predicament, the contemporary condition of society. CRT is both and. It is both and. You have to know historical processes and you have to understand the contemporary. And this is why CRT is seen as a type, well, it's not seen as, this is why CRT also looks at the contemporary condition so that we can do something about these things because we are aware of it. So let's take a look at the Regents of University of California versus Bakke and map this onto Students for Fair Admissions versus Harvard, right, which takes place in 2023. So Alan Bakke, who is pictured here on the slide in the corner, filed suit against the University of California because he was not admitted to the medical school. What he did is he claimed a 14th Amendment violation of the Equal Protection Clause by what? By asserting that he was more qualified than black and brown students that were admitted via an affirmative action program. Now, the affirmative action program at the University of California reserves 16 of the 100 seats in the cohort for non-white students to make sure that the medical professional field would more accurately resemble the population of the United States. However, Bakke said that that particular mission was unfair to him. Peep game. Now, important to understand is that the 14th Amendment with the Equal Protection Clause is a Reconstruction era amendment. What is the Reconstruction era? That's the era that comes up after slavery. That gives us the 13th, the 14th, and the 15th Amendment. That these amendments were put in place to reconcile a people who were previously enslaved, i.e. black folks, into society and to give them a type of social recognition. But we also know that the black codes were there, right? As well as sharecropping and peonage debt and convict leasing and all of the things, right? So we know how, you know, the Reconstruction era went for black folks, but nonetheless, that the 14th Amendment was crafted to ensure that black folk and others would not be discriminated against. However, in this instance, Bakke's claim was that ensuring that black and brown students would not be discriminated against was discriminating against him. Why? Because he had expectations that were extended to him via whiteness as property. That there was a property interest there, that there was an expectation there, that there were rights, that there were entitlements. Right? Now, interestingly, the dean of the medical school had control over 5 seats in that cohort. Bakke did not challenge those seats. Bakke was also rejected from 12 other medical schools. You notice if you did the readings. With some of those medical schools citing what? His age as a determining factor. However, Alan Bakke did not file a claim regarding this either. What was paramount, what was most important to Bakke, catch it, was that the rights due him, that he expected via what? Whiteness as a form of property, were to him interrupted and disallowed because black and brown students were admitted to what he felt he was entitled to. Isn't that something? And further, the Supreme Court affirmed Bakke's rights via whiteness as a property interest by not only ordering his admission. This goes back to what? The centering of the individual. You got to carry these things with you over and above the interests of peripheralized and marginalized groups. You all see how this is connecting? So, by not only ordering that Bakke had to be admitted to the medical school, so then one more seat is created for his what? For his individual interest, and to make sure that the property interest in whiteness would be acknowledged. Right? But the courts also dismantled race conscious programs to do what? To preserve the expectations and entitlements of the property interests in whiteness, which had been present from the foundation of the nation, to go back to what Charles Mills was talking about in that room. All of this stuff ought to be clicking now. All of this stuff ought to be clicking now. Now that was 1978, right? So some people might say, oh, that was long ago, but let's take a look at Students for Fair Admissions versus Harvard that takes place in 2023. Now, in 2023, Asian American students working with Students for Fair Admissions, which is a conservative legal group, claimed that their scores were higher than that of Black and Latino students that were admitted to Harvard. And they said that, hey, we're being admitted in lower numbers, and that admitting Black and Latino students here is an issue. This is what they're placing before the court. Now, other than the fact that more than test scores go into an admission decision in college, right? For some reason, there's this popular belief that, you know, if you score high, you have this GPA, your admission is guaranteed, right? As someone who works in collegiate spaces, I assure you that you need more than a score. But in either case, despite that, the group of students did not challenge legacy admissions. They did not challenge the admission of children, of those of wealthy donors, and they did not challenge the admission of those who were considered athletes. You remember long time ago, well, not long time ago, but it was some time ago that there were scandals that were breaking out because people were being admitted as athletes and they weren't really athletes. There was no challenge to that. But those groups together made up 43% of Harvard's admits. Yet, those students, via Students for Fair Admissions, the conservative legal group, did not challenge those admissions. What did they do? They grounded their claim in their expectations. Here we go. Via their proximity to whiteness, focusing their attention on Black and Latino admissions. Their ask of the court was that race not be considered in admissions. And what happened? The court ruled in their favor. Now let's map these cases onto one another here, because there's going to be some very important things that happen here. In both cases, Bakke in 1978 and Students for Fair Admissions in 2003 insisted that the consideration of race be removed from admissions decisions because a consideration of race to them worked to balance historical injustices, which did what? Disfavored them. So the fact that the university is making an attempt and saying, okay, well, we need to do something about what has happened historically here. You have groups that are saying, hey, that's disfavoring us, and that we deserve, hear this, we deserve to retain that which was ill-gotten in the first instance because it is now our right. It is now our entitlement. It is now our expectation. It is now what? A social norm that must be what? Protected and acknowledged by law. So we are now going to lean on the 14th Amendment Equal Protection Clause that was really intended to map those who had been enslaved back into society. We're now going to invert that and say that what we had then, we must also have now, because our equal protection necessarily, we know, means the inequality of differing groups. Oh man, I hope you all are catching this, right? So as they are laying this down, what we must understand is that Students for Fair Admissions, that particular legal group, the conservative legal group, collateralized the lives of Asian American students to further reinforce whiteness as property. How do we know those lives were collateralized? Because interestingly, like the Ozawa case, this is why I kept driving Ozawa home for 2 lectures straight here. The students who filed the case, despite winning in court, ultimately lost. And why? Because at many universities and college campuses, their acceptance numbers actually decreased. Oh, there's a lesson to be learned here. There is a lesson to be learned here. Despite this, yet whiteness as property persisted, and white acceptance in enrollment continued undisturbed. Now, what both cases here make clear is that the leveraging of the 14th Amendment to reaffirm and reinforce whiteness as property, and further, that colorblind approaches ultimately also work to reinforce whiteness as property, as a property interest, much in the same way that diversity, equity, and inclusion, follow me, does the same thing when companies hire non-dominant persons but insist upon maintaining a work culture environment which privileges and centers the expectations, customs, work office norms, and understandings of whiteness via the insistence upon of standards of professionalism, which in itself is informed by race, i.e. whiteness as property. And therein is the connection between the challenging of these admissions in university campuses and DEI efforts. That in the DEI efforts, it's not just enough like to hire folks, right? But the DEI is supposed to do, if we take it authentically, it's supposed to do a real work. But what is actually happening, right, is something else. That is why in this present moment, as DEI efforts are being rolled back, demographics who thought they were not going to be impacted are actually being what? Impacted. And that is the power of understanding whiteness as property. That is today's lecture. I'll see you in the next one. Peace.